easy to strike out that distinction, particularly because the terms implied into the contract may be different depending on its classification in terms of the contract classification. Okay, so I just say, Isaac, your hand is still up. Did you raise it again? Anytime that anybody raises their hand, please, when your issue has been dealt with, try as much as possible to lower your hand so it doesn't resist.
No, sir, I have raised it again.
Okay, please, go ahead.
Sir, please, someone is asking if you can give, if you can allow us to record the.
It's not going to happen, please. Let's move on. It's not going to happen, please. Because I didn't even set the thing, this thing that way. Please, people must be a bit responsible. Attend class.
Yes, sir.
Attend class.
Yes, sir.
All right, so I continue. Once we have determined what subcontract it is and what the express and implied terms of the contract are, we also need to consider the consequences of a breach of the contract. For example, where one of the parties fails to fulfill its obligations under the contract, as perhaps also imposed by the contract. So in some cases, and in this instance, when I talk about damages, I'm talking about monetary compensation for the breach of the contract. In other circumstances, it may only leave, the aggrieved party with a remedy sounding also in damages only. And I will revisit this, where there is the possibility of actually getting damages as a consequence for violating breaching a contract. And another aspect of getting damages and then also repudiating the contract. Okay, so I'll be using set terminologies as we go, and I will as we go. I wish that as much as possible, that is why I think I open up the class about 30 minutes, more than 30 minutes. And I expected that people would join, and so by the time we set up like this now joining, minimize at least. Because I don't want to keep people waiting too much behind the room, and as such also it leaves a lot of contradiction. So, distractions, that's distraction or bring distraction. So subsequently, I expect that most of you will be in class before, just like you'll be in class before your teacher comes, so that we don't get this. I also appreciate the fact that sometimes your network drops and you have to reconnect and all that. But I think if we have many of you actually joining 10 minutes before time, it will help. And subsequently, we are using this link. We are not changing the link. It's the same link I sent last week that I'm using. Because I've set it that we will use it for about 7 times. Okay, so I have a hand. Yaya, you raise your hand. Go ahead, Yaya. Or you dropped your hand again. Okay. All right, so again, let me say here that even if we know precisely what the terms of the contract are, there may be an issue concerning something we call misrepresentation made by maybe one party to induce the other party to enter into the contract. So, and this may be a particular problem where the contract says on its face that it represents the entire agreement, for example, between the parties, and nothing else counts. All right. Obviously, the law has to provide remedies for misrepresentations in appropriate circumstances. And so these are the fundamental questions that this lesson would actually consider and address. So quickly, let's move on to, the question of what is a contract. So as you can see, I say a contract is an agreement or a promise between two or more people that is enforceable by law. And this is key, agreement, enforceable by law. Okay, so an agreement is for what? We're trying to find out what an agreement is. And we are saying that it's basically an accepted proposal. So if Mr. A or Kwame proposes, to buy lunch for Kwesi, and Kwesi agrees that, okay, thank you, there's an agreement. The question is this kind of agreement a contract? Well, let's move ahead and see. So the next point I'm making is that an agreement consists of two elements. And that is offer or a proposal, or if you like, a promise, and an acceptance of that offer or proposal or the promise. So to be legally binding as a contract, we say a promise must be exchanged for adequate consideration. And I highlight the word adequate consideration. So what is adequate consideration? To be legally binding, which is the aspect that we refer to in point 1 as enforceable by law. And so therefore, let me make this people briefly continue. All right. Okay. So to be enforceable, to be legally binding, there must be an exchange in terms of the promise, adequate consideration. So when I talk about adequate consideration, what do I mean? So adequate consideration in this context is, what you would refer to as a benefit or a detriment that a party receives that reason, okay, and fairly so induces them in terms of the parties, agreeing to make the promise or a contract. That is adequate consideration. There must be a benefit or a detriment. So when I talk about benefit or detriment, what it means is that, going in contract, what is it that they stand to benefit or gain, and what is they stand to actually lose? So there must be that kind of responsibility. You have a responsibility to do something, and if in the event that you don't do it, you lose something. That is what normally would induce people to actually try to get into a contract, because there's something to get, and there's something to actually lose if you actually do not perform the contract or you're part of it. So, for example, promises that are purely gift are not considered enforceable or adequate consideration. Why? Because the personal satisfaction the grantor of that promise might receive from the act of giving is normally not considered adequate consideration. Let me admit this people briefly. So the question is then, is what agreements are contracts? What agreements are contracts? Because we are saying that if there can be agreement, an offer, an acceptance, a promise, an acceptance, a proposal, an acceptance, but it is not all agreements that are contractual in nature. So my question is, what agreements are contracts? And so you realize clearly that, okay, so I have Isaac, your hand is up. Go ahead.
Yes, I want to answer everything. Correct.
Oh, you want to answer? Okay. All right, go ahead. I meant it to be rhetoric, but go ahead.
Mutual agreement.
mutual agreement, you say that agreements that are contracts are mutual agreement, and it doesn't suffice. Because what do you mean by mutual agreement? Mutuality means that we agree already. So you have only repeated what an agreement is. But what agreements are contracts? That's my question. What agreements are contracts? Okay, anybody, trying to do this. Basically, if you look at what we have defined, then we'll say, okay, so I can see Bright's hand there. Right, go ahead.
Okay, so with the contract agreement, from my side, I would say it comes with terms and conditions which one has to comply.
All right, so what would you refer to those terms and conditions? Because I said, a contract is an agreement or a promise between two or more people enforceable by law. So it is only those agreements that are enforceable by law that becomes contract. It's as simple as that. And that should be your response. If the contract is not enforceable by law, if an agreement is not enforceable by law, it's not a contract. Basically that. So if I ask the question, what agreements are contracts? They are those agreements which are enforceable at law. That's it. So if you look at a contract, it is the law of those agreements which create basically obligations and in case of non-performance, in case of breach of that contract or that promise, all right, by one party to the agreement that both have entered into, the other would have a legal remedy, and that is the bit that becomes the enforcer. Okay, because if the contract is not one that gives those legal obligations, then you cannot enforce it at law court. And so those obligations are, to the extent, as I had already spoken, that would hold those who violate the agreement responsible, and not responsible by their own accord, but that there is a law that backs holding such parties to the contract responsible for violating or not meeting their part of the bargain. So to be legally binding, indeed, those contracts that, those agreements that result in agreements are those that become enforceable, those that have adequate consideration. And so a contract, as I would summarize it, consists of two elements, and those two elements are an agreement and legal obligations. And look at it. I looked at the elements of an agreement, a promise, and acceptance. Similarly, a contract, there must be an agreement and there must be a legal obligation, two elements as well, right? And so, if these elements are present within, a particular state between two people, then we are saying that there's a contract. So agreements which are not enforced in a law court are not contract. So there can be agreements, and those agreements cannot be deemed as contract. So such agreements do not give rise to contractual obligations and are not contracts. So basically, I would let's say let's let me admit this, guys, and let's actually try and see some examples. All right. So look at this example. So let's look at example one. Let's look at example one. A invites B for dinner in a restaurant. B accepts the invitation. On the appointed day, B goes to the restaurant. To his utter surprise, A is not there, or A is there but refuses to entertain B. Question: can really B have a remedy against A? And in fact, if A is present in the restaurant but B fails to turn up, can A also have remedy against B. These an example. All right? But and look at how I have put it. So, would you say in this example, there's a contract? I'm still admitting and getting instructions. Okay. You get it. So look at example 1. So I'm saying that neither A or B has remedy against each other if any of them actually fails to live up to their promise or the agreement. And why? Because in this scenario or example, there is nothing that actually binds anybody to by law. I just promise you I'll take you to lunch. I show up, I do not actually buy you the lunch, or I decide not to even show up at all. Because this kind of, but in the first place, the question is there agreement? Yes. Why? Because A invited somebody, so there is a promise of a sort, and B actually accepted that A says you buy me dinner, so there is an agreement. But purely, this is an example of an agreement that does not give rise to a contract, and therefore actually states that agreement does not necessarily lead to contract all the time. And so therefore, there can be agreement that will not have legal basis. Look at example 2. A gives a promise to his son to give him a pocket allowance of 100 Ghana cedis every. In case A fails or refuses to give his son the promised amount, his son has no remedy against him. There again, this is promises that are purely non-contractual in nature. I give you a promise. I'll give you pocket money. And then I'm not giving you. You cannot drag me to court. Dad, I said I'll give you pocket money and I didn't give. Because in this circumstance, there is no, legal basis for establishing, such. All right. Now, I make the point that from the above example, a contract is an agreement, but an agreement is not necessarily a contract. Similarly, all legal obligations are not contractual in nature. A legal obligation having its source in an agreement only would give rise to a contract. I need you to understand that, because not all agreements are contract, and we have seen that. And I'm saying that all legal obligations are not contractual in nature. The fact that there is a legal basis for something and I've not entered into a contract, in any form, does not mean that the law will catch up with me. So a legal obligation having its source in an agreement is that only which will give rise to a contract. So it is very important that we understand that concept. Now, let's look at the third example. So all these two examples, we've seen that, do not give rise to adequate consideration, and so therefore we cannot actually accept as a contract. But let's look at this. So A agrees to sell his motor bicycle to B for 5,000 Ghana cedis. The agreement gives rise to a legal obligation on the part of A to deliver the motor bicycle to B, and on the part of B to pay 5,000 Ghana cedis to A. The agreement is a contract. If A does not deliver the motor bicycle, then B can go to court of law and file a suit against A for non-performance of the promise on the part of A. Why do you think this is a contract? Anybody? What do you think? Is this really a contract? And why? Yes. Let me see your hands. Example 3, nobody wants to. Why do you think that this? Okay, so I'm seeing 3 people raise their hands. Okay, so Kodia.
Sir.
Yes, take the first shot.
Sir, there is an agreement that needs to be fulfilled by both parties.
Mhm.
So it is legal if B decides B decides to take A to court when the bike is not delivered.
Okay, so what makes it legal? What makes it legal? Why do you say it is legal if it doesn't, what gives that indication?
Okay, so they are exchanging services.
This is the business.
Somebody, is it Kodia? Is it your
No, please.
feedback from your end?
No, please.
Okay, the fact that you raise your hand, those who have raised your hand, if you raise your hand and I haven't called you, don't unmute so that we don't get this feedback. Somebody is giving us bad feedback. Please check it. Because if that's going to happen, then I'm not going to allow for even questions, and then so it means that I'll just have to do it quietly. People are just going to, and I think it is somebody called Nicholas, and somebody should tell him, Nicholas Luttrell, somebody should tell him to mute. Thank you.
Okay.
So can I get whose hand is up again?
Sir, I was on the floor.
Okay, Kodia.
So I was saying that they are exchanging services. So with this aspect, there's a contractual agreement. That is why.
Services. Okay, so that's what Kodia is saying. Ima Akoto, what do you think?
Okay, so it's based on the example you gave. The agreement now turns to a legal obligation, and then in the statement it states that the agreement is a contract. So
fantastic. That's the point. You get an indication from the scenario that he says the agreement is a contract. Okay, and now my next question would be, it says that if A does not deliver the motor bicycle, then B can go to the court of law and file a suit against A for non-performance, right? If A does not deliver the bicycle, why do you think that B can go to court and it's justifiable that he can go to court because A did not actually deliver? Because if you look at it, it says that the agreement gives rise to a legal obligation on the part of A to deliver the motor bicycle to B, and on the part of B, so it is upon delivery and make payment. Why is it the case that if A does not provide or deliver the bicycle, B can go to court? If you look at the scenario, because on the part of A, there's obligation on the part of A to deliver the motor bicycle to B, and on the part of B to pay. So one would have thought that, so if A, you did not deliver it, okay, I've not also paid you. So why should I actually go to court and plead before the court that, okay, so A did not deliver the bicycle? Vincent. So Vincent.
Yes, sir.
Yes.
So I think the only reason why B can go to court is because in the contract there's an obligation for A to deliver, and B is also expected to make payment. So should in case B has made a payment and A has not delivered the motorbike, then where B can go to court.
Okay, so my question, Vincent, is that, okay, in this case, if A does not deliver the motor bicycle, B can go to court. Why can B go to court if A did not deliver? What explanation could you give as the justification for the court to even grant this? Yes, we have established that there is a legal obligation for each one of them to perform their bits. And I need a bit of clarity or explanation as to why we think that B can go to court when A has not delivered and B has not paid.
Sir, I think it's for non-performance.
for non-performance. All right, okay. Listen, that's fine. Jamal. Jamal. Please.
You hear me very well. Hello?
They let them mute your microphone and still externally, please. This is very commonsensical, please. They let them mute your mic. You are not interested in your external communication. You are not interested in your. And he is still showing, his microphone.
Listen, data structures and listen.
You see what
you can mute him. Sir, please, you can mute him yourself.
If I have to do that, it means that I have to actually. I have to now be exiting and muting and that kind of distractions. All right, so I had who?
Yes,
Hafiz, right?
Yeah.
So, yes, I'm mute. Jamal, let's go.
I think the reason is because B has violated the contractual agreement between himself and I mean A.
So my argument is that A has not delivered or did not deliver.
Yes.
So why should B go to court?
Probably in the agreement, since they are bounded by legal obligation, then I think B can go to court because A did not hold his end of the bargain.
Okay. Anybody else have? Okay, let me see those hands that are there. All right. So Frederick.
Yes, sir.
Jamal, you can lower your hand. Frederick, yes.
Yes, sir. Sir, please, I think B can go to court because A has actually breached contract because there was a verbal contract between A and B, and A failed to deliver. Per my understanding, I think there was a breach of contract on the part of A.
Okay, what if in court A says that, well, after all, I'm not taking your money, B?
Yes, sir, I do get your point, but sir, in our country, we have, per my understanding, we have two types of contract. That is a documented contract and a verbal contract. What transpired between A and B was a verbal contract that was supposed to be delivered.
There's no argument about the fact that a legal contract or a binding contract exists. All right, but I'm looking for what would in the minds of the lawyers or the argument that we adduce as the justification beyond the fact that yes, there's a contract. So there's a contract, basically. So let me come here. So basically, you see, the basis is this, that, okay, why can B go to contract, to go to court? It is one of the case that B, assuming indeed A delivered the vehicle and B did not have the money to give. That is why we say that, okay, then A can actually go to court and say that, look, it was agreed that I delivered, and B did not pay me. Why? Maybe B didn't have the money down, may have used the money to do something else. Unminded about the fact that he has gone into some agreement that has a legal basis. The same thing, if A does not deliver, what he meant is that B would have kept his money, that he could have actually done something with it to get some profit on it, but he knows that should I actually take this money somewhere and do not keep it, quarantine it, for me to give it to A when A delivers, then it means I would have actually disappointed and violated the contract. And so the fact that B has to hold the money, which he could have actually been gained trading with that money, you're doing something with that money, and then the time comes and you don't deliver, B has lost the potential or the opportunity to actually make gains on his money. And so on the basis of that, even alone, it tells you that, so because the point is that I said a benefit and a detriment, there must be a loss. So if A doesn't actually provide or deliver the vehicle, what has B lost? He has lost opportunity to actually invest his money and get something, a return. Because anytime that you tie down funds, you are losing the potential to make money, an additional money. You get it? And so in the minds or deep down beyond this is that notion that, hey, you cannot expect to let somebody hold down something that he could actually turn around because, there is an obligation that he has to meet and then not show up. And that is why, even though A does not take B's money, B still loses in the circumstances if A does not deliver. And similarly, if actually A delivers and B says, I don't have money to give you, A could also have actually gotten even a higher bargain on price than B after that agreement with B. But felt that, no, hey, I've already gotten into agreement with B, and therefore, regardless of the fact that, there's even price soar, I lose. I cannot say that, I will not deliver to B so that I'll give it to somebody else where I can get much more money on it. You see, these things actually play. All right. So that is, the essence.
Why can't take
Why is the LATAM behaving this way?
Come here.
Anyway. All right, so I can see a lot of people are, how are they? Okay. All right, so somebody's on, Sadiq Amba, your hand is up.
Hello, sir.
Yes.
Sir, I'm confused about this legal obligation. Because I'm saying this because if I decide to sell you my motorbike and I don't show up to sell, I don't fulfill my side, I don't show up again, and you choose to take me to court. Why? I don't understand why.
But I just explained, unless you didn't hear me. It is not that you chose to sell. You went into agreement, first of all. And the agreement gave rise to a contract. That's what we're saying, obligation. As the situation actually is, on and out. All right? So it means that we have already established that legal basis. And I did explain why it is the case that B or any of the parties can go to court on the basis that, the fact that you have agreed, what it meant is that B would have to make some money available down, such that when you come, he will be able to meet his obligation. And in keeping that money down, when he could have actually made some gain or given to somebody else, or could have even bought something at a cheaper price with it, cheaper than what you said, and the fact that you now do not show up to bring it, he has lost, because I said that for it to have, adequate consideration, there must be a benefit and a detriment. And the detriment to be here is the fact that he has lost for keeping down money for you and you not showing up to deliver the vehicle. So B can go to court. And then likewise A, bringing the delivering, and then B says, well, I'm sorry, I don't have money to give you. A can go to court. Why? Because similarly, A has performed his part of the bargain, He could have actually said, look, I'm selling this thing to somebody else, for a higher money, and I could have, because A would then also lose the potential. There's a potential lose or loss in that circumstance, that A actually, on delivery the vehicle, B chooses not to pay. Because I'm saying that, and I've explained that basically. So that is Sadiq, right? So Sadiq, why? What is your difficulty?
Sir. There's no document to show that or to support the fact that I agree.
Sadiq. Read the scenario again. Read the scenario again. Read the scenario. A agrees to sell his motor bicycle, and it gives you a premise. The agreement gives rise to a legal obligation on the part of A. That is giving you the indication that there was some agreement of a sort. There was a legal consideration, because it says it gives rise to a legal obligation. It is part of the example, the scenario. So why do you get back and say that there was not legal writing, whatever? It's been given you in the scenario. Do you see that?
I see.
Okay. So what will be, where are these people that I need to? Okay, yes, because there are several people I need to admit. All right, okay. So I think I've admitted. All right. Bright, Gidisu, your hand is up. And at some point, I'm going to just move on and not let everybody have their bite, else we can't move on. All right, so Gidisu, your last bite.
Sir, please, my question is, assuming I'm a car dealer, like the contract says, and then the person issued, doesn't mean I can go to court and file a case against the person because I'm selling.
You had a legal obligation, to the extent that that agreement had a basis in law.
Yes.
Yes. You can. That's basically what we're saying.
Oh, okay, nice. Thank you, sir.
Yes, good. Thank you. All right. So, moving on, let's look at the next one that we have on the slide. So here I try to go through, the elements of a valid contract. What must one actually consider? So I have 10 elements to contracts that I want to run us through for us to understand what it takes and what you require to know to go into contract. So first of all, say that, and so permit me to actually summarize this thing in a statement, all right? And the statement I want to make is that all agreements are contracts, and I bring a condition if, okay, they are made in terms of those agreements, all right, are made by free consent of parties. Free consent. So you can see point 3 is emphasis that point 1 say agreement. All right. So 1, 3 are satisfied. So all agreements are considered to be contractual in nature if they are made, those agreements are made by free consent of parties. Secondly, competent to contract. You can see competent to contract, right? Parties competent to contract, point 4, all right? For a lawful consideration, point 2, intention to create legal relationship. And with a lawful object, and you can see point 6, lawful object, and are not hereby expressly declared to be void. Point 7. And you can see that the others that I have not touched on are things that themselves are subsumed in others. Possibility of performance, certainty of need, necessary legal formalities are all, if like some other supporting things that are subsumed in that. So basically, if, agreements must be contractual in nature, then those agreements must be made by free consent of parties who are competent to contract, and the contract must be actually formed based on some legal consideration or have a legal basis, and the contract, the object of the contract must be lawful, and must not, at the point of even getting to endorse the contract, are not declared as void, null and void. And I'll explain each one of this so we can actually appreciate, what I'm trying to talk about here. Let me admit some people. All right. So first of all, if you look at these essential elements, when we talk about agreement, but I'm not going to actually go into agreement again because I have explained agreement. All right. Okay. And we have seen agreement has two elements. Now, if you look at the second point, it's the intention to create legal relationship. And that also, I have actually explained that there must be an adequate consideration. So what gives rise to this adequate consideration, that there must have been a demonstration of some, intention on the part of the parties to the agreement to create that legal relationship. Intent. And it's very important. So at the point of actually agreeing to what, did both of them actually have a certain intention that they were entering into that agreement and have legal obligations or have adequate consideration? What was the intention? And that's why you see in law, we do not only interpret the law on the basis of just the spirit and the letter of the law. We go also into the intent, the rationale of the letter. The letter is the written, piece, but the spirit of the law goes to prove the motive of why the letter was written. At the time of framing that law, what was the mindset of the framers of the law? And so it becomes always important to establish intent. And that's why intent is a very strong, aspect of law, what we call the mens rea, especially when it comes to criminal. All right. So, if, for example, under this consideration of intention to create legal relationship, if I say that, let's say a husband agreed to pay let's say 500 cedis to his wife every month while he perhaps had traveled, was in abroad, all right? As the husband failed to pay the promised amount, his wife sued him for the recovery of the amount. What do you think would be the court's possible judgment on such a thing? That a husband actually promised to remit the wife 500 cedis every month whilst he was away, maybe residing somewhere, holiday, whatever, and then he failed to actually do that, and the wife takes him to court. What do you think the court will hold in such a scenario? Do you think that she could recover?
No, sir.
And why? Why? Because it's here and I'm on point two. Because what actually transpired was more of what? Like some kind of a social agreement. And you could infer from this scenario example that they did not intend to create any legal relationship on this issue. They did not intend. And so basically, when I am talking about intention, it is possible that as much as it may have been under the circumstances, the arrangement, there was no intent to create that legal obligation. If, for example, they created that intention to create legal obligation, then in that case, that kind of agreement would have intended to have legal consequences and therefore would become a contract if they had so actually, created that intention that this must be legally binding. And therefore, in the event that you do not actually, what must happen to you if you fail? What must happen? And the discussion actually goes on to impugn that, hey, then you can use any means or legal means to actually get that money from me. Then that agreement quickly changes because the intention or the motive for actually getting into that agreement had given rise to some legal obligation in that circumstance. All right. Then let's look at point 3. It says free and genuine consent. And what does it really mean here? It means that the consent of the parties to the agreement must be free and genuine. The consent of the parties should not be obtained by some form of misrepresentation of fraud, inducement, undue influence, coercion, or anything, or by even mistake. It should not. It means that nobody should force the other into an agreement. And it must be with people's genuine consent and freedom that they want to actually enter into a contract. So, and that is where sometimes you get this thing that, must somebody force somebody to enter into a contract? It must be done free and genuine. And that is why we can hold people responsible to the performance of the contract because nobody forced you to actually enter into that contract. So free and genuine consent. 4, we're saying that parties must be competent to contract. See, the parties to a contract should be competent to enter into a contract. And the issue is that the legal basis for this is that every person who is competent to contract, or every person, is deemed competent to a contract if, that person is of, a certain age. In this country, we determine that the age of, a senior and not a minor is 18, and under certain circumstances, we say 16, but in terms of contract, 18 years, you are free to enter into, a contract. And you must be of a sound mind, all right? And beyond being a sound mind, you must not be seen to have been disqualified from entering into contract by any legal means. Let's say there is some kind of bond placed on you, not to actually enter into contract because of that. Your attitude in you have demonstrated over the years for just not obeying or following what and so there's some kind of injunction or ban on you for whatever reason that may have led to that decision. And so it is important. You must be of age, you must be of sound mind, you must not be disqualified by any law or be banned from not entering into a contract. So it is very important that going into a contract, you are You know the in and out, and that's why you cannot enter a contract and there is maybe a breach, and you said, "Oh, I didn't know that this part of the contract. I didn't know, ignorance that you know. You must first of all be competent, and if you are not competent, you hire people who are competent to help you. So ignorance under the circumstances will not, because once you enter the contract, you will have satisfied certain conditions that law allows you to. That's satisfied. And so that's basically what is it. Now we are talking about lawful, consideration. Lawful consideration. And so, you see, when we talk about lawful consideration, I think I've already also explained that, because it must be supported by certain laws on both sides, or supported by certain consideration, a benefit and a detriment. So each party to the agreement must give or promise something and receive something. That is, lawful consideration. So I stand to actually gain this if I enter this contract to do this, and I stand to lose if I do not perform my part of the bargain. This is what are the consequences, and these are what are the remedies also, and so there must be both sides what, I'm calling the consideration, because it is this consideration that would actually induce people to go into contract, or to think or establish the intention to go into the contract, because there must be something there to gain, there must be something there to lose in the event of non-performance. So, in the event that there is the whatever agreement or promise is not supported by these kind of consideration, the promise will be, unenforceable. Our law will be unenforceable. Okay, it's in the wait room. All right. Then we have lawful object. And so when we talk about lawful object, basically what this point is trying to establish is that the agreement must be or must not be on something that, for example, the law disapproves. So in essence, it must be one which the law, or must not be one that the law, disapproves. You cannot enter, for example, a contract to supply cocaine in Ghana when the law does not approve the supply of cocaine or the trading of cocaine within its territory. So the object of the contract becomes even void, becomes an illegality. And so you cannot, so the object of the contract must be lawful, right? There are things that we allow to get into, and there are things that you are not allowed to get into. So basically, that is. Then we say agreement should not be declared void or illegal. You see, there are certain agreements which have been expressly declared illegal or void by the law. And in such cases, even if the agreement possesses all the elements of a valid agreement, the agreement will not be enforceable by law. And it ties in very closely to the point 6, the lawful object. So if the object of the contract is illegal, then the 7th condition or element actually kicks in. So if you go ahead and actually establish a contract over a unlawful object, then what it means is that the contract becomes void. And when we talk about contract becoming void or declared void, what it means is that it's like the contract did not even take place in the first place. It did not, even though you might have signed and agreed. Look, it is considered the contract. There hasn't been any contract at all. So dead on arrival. If you look at the point 8, it's the certainty of meaning. You see, the meaning of an agreement, I should say, must be certain or capable of being made certain. Otherwise, the agreement will not be enforceable at all. So, if a party to a contract decides to perform something or gives a promise to perform something as part of the contract is concerned, and the issue is that the two parties involved must be, if you like, competent or sensible enough to say, this kind of promise that I am going to agree to and have a basis in law, is it possible to really do? Okay. So it is more or less to say that if I just say I want to supply another person, let's say 10 meters of cloth, and I just leave it like that. So no, so possibility of performance actually, but the certainty of meaning. Okay, 10. Let's say I want to say 10 meters of cloth to another person, say Mr. Kwame. So let's go into agreement that I will supply you 10 meters of cloth, and then we go into agreement. Give rise to a basis, or give rise to legal consideration, all right, an obligation. Okay, so in the event that I do not supply, what's going to happen? The contract lacks certainty of meaning because there was no specification of exactitude of what type of cloth or color and whatever. So the certainty of the meaning of these 10 meters of cloth is vague. It's not there. What kind of cloth? When there are different types of cloth. So there's no certainty of meaning. But on the basis on the 0.9 possibility of performance, it's just basically saying that, if one promises the time of the agreement, is rich, the performance of that agreement must be capable of performing. If say an agreement to do an act which is impossible in itself to do, cannot be enforced. Because can I go into a contract with another person and give a legal basis to it if the basis of the contract would be that I would discover, let's say, some treasure by magic? Then I enter into a contract. So let's say, A agrees with B to discover some treasure by magic. Possibility of performance. A sane person should be able to actually stay through. Does this really make sense? Because magic is not something that, it is concrete. It is not something that you can say that you would go on the basis of magic. And that is where sometimes, there is that difficulty in understanding, a certain prophet said this, and on the basis of that, you can actually take the prophet to whatever. Those things do not wash in the court. So the possibility of performance must be interrogated. Then the 10th one is necessary legal formalities. Let me add something. Necessary legal formalities. Now, anytime you see a contract may be oral or in writing, as some have been. But if, however, a particular type of contract is required by law to be in writing, it must comply with the necessary formalities as to writing, registration, attestation, at the lodging, copies at the registry of the court. And so if these legal formalities are not carried out, then the contract is not enforceable at all. So the necessary legal formalities must be established, must be followed, must be complied. And so basically, these are the elements of a valid contract. And we'll go into some other, and these are not the only elements to a valid contract, all right? And there are some other elements that we must interrogate and then understand right now. And so, is there any question before I move on to the next? All right, so I see 2 hands raised, so let's do these 2, okay? And then we move on. All right, Bright, go ahead. So I have Bright, who again, so I have Bright and Emmanuel Akoto. Please, let me take these 2. Okay, Daniel, I'll consider for 3. All right, so Bright, let's go. Bright. Okay, Ima, if you're ready, let's go.
Okay, sir. So I wanted to understand the possibility of performance and link it to the necessary legal formalities. I understand the legal formalities for now that once there's an agreement, there should be a registration, attestation, documentation, any legal formalities to back the agreement. But what of the possibility of performance? I couldn't get it well, the difference between it and then the certainty of meaning.
All right, so I go into agreement with you and say that, look, I will plug 3 stars for you in 3 days' time. Stars. And you agree, and you said we'll give it a legal background and we'll go into agreement with that. The question is it possible for any man to actually plug the stars from heaven or in the skies? So it is not possible to perform such. And so you must be aware that as a party to a contract, you cannot go and agree to some of these things and say on the basis of that you are entering into a contract. Then it means that there's something wrong with your brains.
Okay. That's very insightful. Okay.
All right. Who again? All right, so we are fine. Let's make progress. Okay, so the next thing that I'm looking at is terms of the contract again, which are also aspect of the elements to contract. Okay, so who wanted to admit people? Okay, so everybody is fine. Let me admit. So 8 people. Okay. All right. So yeah, I have been saying that a contract term is any provision for forming part of the contract. A contractual term, is any provision of forming part of a contract. See, a contractual term is any provision forming part of a contract. Each term we are saying gives rise to a contractual obligation, a breach of which can give rise to litigation. Not all terms are stated expressly, and some terms carry less legal gravity as they are, considered to be, peripheral to the objectives of the contract. So when we talk about a contractual term, we are referring to the provision of that term actually gives the basis for the contract. So we have what we call terms of contract. And I'm saying that what are the types of the terms of contract? There are two basic types of contract or terms, contractual terms. And we said the implied terms and the express terms. And I'll go ahead and define them as you have seen. And so I say that when we talk about express terms, all right, they can be, defined as the terms that have been specifically mentioned and agreed by both parties at the time of, making that contract, and they can be either in oral or in writing. So those terms that have been specifically agreed and mentioned in the contract by the parties at the time of making the contract. And those terms can actually be, the express terms can be, in oral or in written. So the terms which parties to contract explicitly, include, in a contract are basically the ones we are talking about as the express terms. So if the intentions of the parties are not clear from the express terms, then it may be necessary to imply terms into the contract. So what is the real actual provision of the contract? So in this contract, party A agrees to do A, B, C, and party B agrees to actually do also this, that. It becomes the expressly stated or agreed upon, whether even it is oral or it is written. We say it is the express term, specifically mentioned and agreed upon by both parties. Implied terms, on the other hand, would refer to practice of setting down by the court, normally, the default rules for contracts. Okay, so and so it means that setting down mandatory rules, okay, which usually operate to override the terms that parties may have chosen themselves. Because the purpose of this implied terms is often to supplement a contractual agreement in order to make the deal effective for the business purposes and to achieve some level of fairness between the parties, or to relieve any hardship among the parties. So it is very important that we understand that when we talk about express terms, the very key terms making provision or provision of the contract, that forms the main part of the contract. So in that case, what we're saying is that if there is, for example, a violation, all right, what did the two of you agree to do? That is the term, the express term. Okay, what you two actually agreed to do, is this something that people or parties competent to a contract must have agreed? Is it all that there is? That parties competent to a contract must agree? Or there are some other aspect that, going into such a contract, you ought to have considered some other things that, because of either naivety or you're incompetent to contract, you did not consider. And so in the event that, a contract of a certain caliber or nature ought to have considered certain terms as express terms, forming the main consideration or provision in the contract. They do not do, all right? And there is a litigation of a sort, on the basis of this contract. What the court would then do is that, okay, well, they would actually, look at the nature of the contract and say, okay, so a contract of this nature should have, considered this and considered that before even going to that. Okay, so on the basis of that, we set down these other terms and imply what you should have actually considered. Because this contract ought to have actually, because without it, it would not actually suffice on its face to be able to actually give a fair ruling or judgment. So implied term is when the court actually decides that, okay, the contract of this nature must consider this and that. And so the court can actually imply those terms on the basis of that to now give a fair view of what the actual complete contract should be. So that is the distinction between express terms. So express terms are specifically mentioned and agreed upon by both parties, and implied terms are not mentioned but assumed are intended to be included in that contract. So in the event that there is any litigation, the court would want to actually believe. And so you see, there are, and as I'm saying, let me have made this 13 people. So as I'm saying, there are three methods by which the court would imply terms. Because as I said, the purpose of the implied term is to supplement a contractual agreement, what has already expressly been stated, and what may have actually been left out, which without does not actually provide the full validity, not the validity, but the full picture of that contract. So as I go ahead to actually explain the methods by which the court actually implied terms, perhaps we'll get the better picture of this distinction. Because as I said, the court can imply terms by either custom or a trade. So I'm talking about custom like the way we know custom people, all right? Or the court can imply terms, by itself as the court, and they can also do that by statute, all right? And so if we talk about, contract terms implied by, say, statute, what I mean to say is that traditionally, legal statute had little impact on a contract freely entered into, okay? I mean, legal statutes had very little impact, all right? But, increasing. Terms are implied by statute which, may take precedence to the express terms of the contract. For example, a landlord and, say, a tenant may agree that by way of a deposit, the tenant will give the landlord a painting. All right, and I want you to listen carefully. And the tenancy agreement may, for example, include an express term stating, this agreement that by way of deposit, the tenant would give the landlord a painting. All right. However, according to the Housing Act, a deposit in relation to a short hold, residential tenancy must be in monetary form. And yet the landlord goes and says that, give me painting in place of your deposit. It becomes that position and agreement by this landlord and tenant becomes contrary or violates the Housing Act, which is statutory. And therefore, that law may override the express term in the contract between this tenant and then the landlord. And so it becomes statutory provision. And there is no agreement of any sort that must go against statutory provisions. And so, yes, there is a contract, but the court under such dispute would actually imply the statutory term into the contract in order to give fair judgment. So one way by which the court imply terms is by statute. This is what the position of the law is. And then we cannot go contrary to it, regardless of whatever agreement that you have got, because that agreement will then go contrary to what the statutory provision is, and on the basis of that, it cannot pass. So they will apply that term into the contract and then use that as a basis to actually, arbitrate the matter. Okay, let me admit this with people. Now, terms implied by court. How is the line? You see, the court may imply terms into a contract normally to give effect to the intentions of the contracting parties. So generally, a court will only imply a term into a contract where it is obvious that it represents what all of the parties intended when they entered into that agreement, and where the term is necessary to give, if you like, some form of what we call business efficacy to the contract. So the court would imply into that circumstances, terms, what actually may have been some consideration that the parties to that contract ought to have intended, or may have intended, but did not actually, intend so, and yet implying that into that contract would give that contract the business efficacy in terms of the strength of that contract. So the court may imply a term into a contract if it is necessary to do so for the contract to comply with, let's say, for example, common law. And so it is important that if, you see, the court would imply, terms, not by statute, by the court itself, only to the point that on the face of the contract and evaluation of the contract, it is necessary that the court actually implies those terms to give the entirety of that contract, its potency. The court is able to do that. And so one aspect could be that, look, there is a certain common law that must have been considered, and that was not considered, the court would imply those terms to give it, its efficacy, all right, the potency that it actually requires. Because normally, and normally with, modern, contracts that, they are entered into because of the involvement of, to a large extent, lawyers or people who are competent to contract to support parties who are not competent in that. Some of these would necessarily, some of those terms may have already been implied into the agreement, because those aspects would have been contained in some legal statute already. And so may normally be difficult to skip those kind of things. So, the court would normally not imply terms just like, because it is deemed that before the contract even gets to that extent, some of these, necessary elements of the contract that ought to be considered to give the entire, contract its business potency that it requires, it would have actually been considered. All right. Then we said that, terms implied by custom. So we said that, some contracts may be entered into in the context of widely accepted business practices that are common to all contracts of that type, all right? So even if the contract does not include an express term, that the practice within that, let's say, domain or industry, actually applies, it may be implied that it does. So if the parties decide that the practice or custom will not apply in a particular, trade contract or that, they may have to include an express term excluding that aspect. So I'm saying that the terms implied by custom would normally or is normally enforced according to the custom of the market in which the contracting parties are operating. So there may be already existing terms that operate within a particular industry that if you are actually going to engage in contract of a sort, you would want to actually consider. If those are not written or considered within the contract, they would have to be included. If the parties have, for example, included an express term excluding the usual practice within that industry also, normally the court would imply, term by custom by considering that aspect of the contract, which within that sector or trade is necessary to always actually include and make it a precedent for them to actually consider it to the general custom which applies to that sort of contract. Because every industry or trade and certain things that govern them. And so you need to understand the industry or the sector that you are operating in, and in the event that you are entering into a contract within that sector, you must be privy or knowledgeable as to how some of these contractual agreements are actually drafted within such. And so in the event that some aspect of the things that actually, transpire within this industry are not considered the court would imply them and explicitly ensure that it is included. And on the other hand, if it is something that is there expressly that actually contradicts with those kinds of agreements or consideration within that sector, the court will actually also step it down. And so I'm using terms implied by custom because the custom in here is referring to some trade. So it is the custom of that trade. Just a second, let me pick this call and then get back to you. Okay. Oh. Oh. All right, sorry about that. Thank you. Thank you. So basically, these are the three ways by which the courts imply terms. Terms implied by statute, terms implied by the court, and terms implied by the custom of the particular trade environment and things that actually happen there. And the court will say, normally, these contracts of this nature within this, then ought to actually consider that these are the, if you like, unspoken stuff that must be considered. And so the court will imply into it to give also that contract, the needed, efficacy within it. So basically, that is what we mean by terms of contract. There are also other terms that we would want to consider. All right, let me get these guys in. So, So, what are some other so other terms of contract? Still, I mean, this guys, this animation. All right. So, apart from the express terms and then implied terms and the ways or methods by which the court would imply terms, there are also other terms to contract. One of such is what we call inconsistent terms. Inconsistent term. And you see, conflicting terms in the contract that cannot be adhered to because of the clashes it creates within the contract as a whole is referred to as, inconsistent term. Additionally, conflicting terms in a contract may actually exist if there are certain terms or definitions that are inconsistent throughout the contract. So you may have situations in which conflicting terms may occur, and some of those conditions are what I have actually listed here. And I think that I'm making reference to a certain case, and I'll project the case to expatiate on what these conflicting terms are. All right. And so there are conditions or situations that may give rise to, conflicting terms within a contract. And those conflicting terms is what we are referring to as inconsistent terms. A particular term agreed in a contract, and then in the course of the contract, there are some changes, and then some terms are introduced. And those terms that are introduced later actually become inconsistent with the initial terms that were agreed on. Then there is an inconsistent term. And we are saying that, there are situations where that creates this kind of inconsistent terms to be, present in contract. So, for example, when there are multiple parties drafting the contract, so therefore, some would agree, to the contract at some point, oblivious of what others have already agreed on, and therefore the terms will conflict, or the involved parties are not thoroughly clear on the terms, or any revision being made to the contract. When maybe some party may not be privy to some revisions that have been made on other part of the right, and the situation arises, and that you see, that there is litigation, and then you can see that but that is not what we agreed on. So eventually, at what point did we actually agree on this, or this aspect of the contract actually terminologies is being used that may be familiar to those who work within a specific industry, but may not be familiar to, let's say, other people or lay people within. And so, for example, it happens a lot between IT technology, or technologically inclined, persons drafting IT contracts with lay people. All right. So they may introduce some jargons and then or clauses that actually may, get them to dodge, certain responsibilities, and this may not be actually apparent to the other party because he's late to contract, and terms and conditions of the contract are not being clearly spelled out to all of the necessary parties, can also actually create such problem. And in a way to actually avert that, is normally, at the end of the contract, the terms of the contract, there will be that insertion of a particular statement that says that the contract constitutes the whole agreement between the parties and seeks to prevent the parties from relying on any preceding agreement, negotiations, or discussions that have not been set out in the agreement. Normally, you will find this in contract, stating that this is the whole agreement that we have agreed to. And therefore, anything outside of these agreements cannot be considered. They put in such clauses because of the possibility of the introduction of inconsistent terms, so that this forms the whole part, part of the agreement between so and so and so and so and so. They don't just put that statement there for nothing. It is because they want to say and provide evidence to the effect that, okay, this, every term that has been considered here, we are all privy to. So before any one of them will put their hand under this and take this portion of that statement, or agreement, would have actually been allowed to go through the contract and say that, yes, I agree to this contract wholly, because this is what I actually set out to do. So let's take a look at the example here. I want you to read this example. All right? Take a minute and read this, and let's digest something here. Because it is... Hello? All right, so just read it for me.
BCT solution, software solution versus the Arnold Lever and...
Oh, no, you know what? No, let every individual read it on their own. No, sorry.
Oh, okay.
Don't read it aloud, yes. So that, and try to build understanding. So I'll give you, let's say, 2 minutes or 3 minutes to try read maybe 2-3 times and see if you understand this. So it's a case that I had picked. Okay, so I want to believe that at this point, you may have understood what is at play here. And so, right. Why do you think the court actually ruled that the client could continue to use the software without they allowing the claimant in this point? So I want to use the terms because I want to see whether you have understood the context of this case. The claimant could not stop the client from actually using it and treating it as a separate, contract. That their continued usage is not dependent on the payment of service that they will require, if you have understood the case. Why do you think the court actually gave a fair ruling? Maybe let me put it that way. Do you think that the court really gave a fair ruling in this matter in terms of their interpretation of what this thing is, in line with inconsistent terms? Have you understood? Anybody? I want us to have some little discussion here. It's almost 11:45. And see, my God, I didn't finish this topic. Come. Oh, God. It becomes interesting. All right. So BCT Software Solutions Limited versus Arnold Lever and Co. Concern a contract purchase or a contract to purchase software. The quotation submitted by the software developer made reference to the developer's new and revised standard terms and conditions, which were inconsistent with the terms as really agreed by the parties. All right. Okay. The terms expressly agreed treated the grant of the software licenses on ongoing maintenance as two separate issues, and failure to continue to take and pay for support would not bring the licenses to an end. That aspect is very critical. Okay. And so the new standard terms and conditions made the license to use software conditional on the client continue to pay for support services. Okay, that's another catch. And the software developer went into receivership. All right, go. Let me actually probably break it down from this point and find out. Okay. So what really gave rise to this litigation? First of all, what it meant is that there was a contract between a software developer and then some company, Arnold Lever, all right? And then at some point, and they actually agreed on the terms of the contract, all right? Okay, and treated some things as two separate stuff. Now, the software development house goes into receivership, and so what does that mean to go into receivership? And the claimant acquired the intellectual property rights of the software developer, and the client informed the claimant it no longer wanted support. That is where the issue started. Don't you think so? So the software developer went into receivership and the claimant acquired the intellectual property rights. So in this case, the claimant is the next successor or the new owner of the intellectual property right of BCT Software Solutions, because they went into the receivership. And if they did so now the claimant who has gone to court over this matter necessarily was not the one who initiated the initial agreement. Was not the one who initiated the agreement. So supposedly when they took over, what happened? They actually sent a new standard terms and conditions that made the licenses to use the software conditional upon the client continue to pay for support services. Inconsistent term. Inconsistent to what? To the initial agreement between the software developer and the company. And that is what gave rise to this. the initial agreement, which was expressly agreed, the terms expressly agreed, treated the grant of the software license and ongoing maintenance as two separate issues. And failure to actually, take to use the company as to provide the same to provide maintenance services did not invalidate the contract in any way, and that is the position of the first agreement. So I have Jamal raising hand. Jamal, let me hear you.
Yes, sir. I'd like for you to explain what it means by to use the software conditional. They made the license to use the software conditional upon the client.
Okay, so the new standard terms and conditions made the license to use the software conditional upon the client continuing to pay for support services. If you look at that, that is coming from the initial, something that has been said already. The terms expressly agreed treated the grant of the software license and ongoing maintenance. So that is where the ongoing maintenance, right? Now he said the new standard terms and conditions made the license to use the software conditional upon the continuing of the client continuing to pay for support services and maintenance. That is what it means. You understand? So what this actually is saying here is that when the new software license owner came in, or let me even begin by saying that the terms that were initially agreed treated that your usage of the software and then the provision of maintenance services to the software are two different things. What it meant is that you can use the software and not add. So let me use the company so you can understand. Arnold Lava Company could use the software developed by BCT and not allow BCTU to actually provide them with maintenance services. Means another company can actually provide them with maintenance services of the software. They are not under obligation. So they are continuing use of the software.
Every day Zoom like for morning. No.
Barabu. Please mute your microphone. So basically what that is saying is that a developer has created software for a client. They have gone into agreement and say that, you see, we still have maintenance services that we provide. You can choose to let us, the developers, provide you with a maintenance service, or you can choose to get your maintenance service from somewhere. In fact, your continued usage of the software and the license you have obtained from us will not bar you from using another company to provide you with maintenance services. So it says that it treated those two as separate from the initial agreement. Is that Hafiz, Jamal? Have you understood that point?
Yes, I have.
Okay, so therefore, if here it is saying that the new standard terms and conditions made the license to use the software conditional. What it means is that now when the new software owner came into place, he says, no, if you want to continue to use the software, you must allow us to provide you with the maintenance services or the support services. And then Arnold said, no, our initial agreement did not suggest that. And so you bringing in this term, you are introducing a term that is inconsistent with the expressly agreed terms. And then the new software owner says, well, then I'll take you to court. And the court actually gives a ruling and says, no, yes, this was under inconsistent terms. And you see, I explained a while ago, the conditions and circumstances under which, such inconsistent terms can occur in a contract. Because,
not to remember.
Because the new owner was not the one who actually drafted the initial agreement, and perhaps did not take time to really understand or read everything to know that the continuing usage of the software is not conditional on the client actually opting for the company that developed it to actually provide the maintenance services. So that's what that line is saying. And so to the extent that now the new, owner is saying that, well, then I'm going to stop you from using the software. Because if you want to continue to use it, then you must allow us to provide you with the maintenance services. And then the client says, no, you can't do that. And so the new owner says, well, then I'm going to court and I'm going to sue you for damages that you are continuing, because they brought that, a new standard terms and made that standard term because you have taken over, you have owned it. Oh. All right. So that is inconsistent. Have you understood situation where inconsistency can actually create problem?
Yes.
Okay.
Yes, sir.
Okay, that is good. So basically, normally this is when it comes to this inconsistent term, and then Kodia, your hand is up. Go ahead.
Yes, sir. So in this scenario, who wins the case?
Oh, but the case is that, but in the output is that the court held that in a case where any of the terms imported into a contract conflicted with those expressly agreed between the parties, the latter would prevail. What was the latter? That, the claimant, okay. So therefore the client could continue to use the software and the claimant was not entitled to the damages.
Okay.
All right. So the latter is that, what is it? I said, in case where any of the terms imported into a contract conflicted with those expressly agreed. So the latter is those terms that expressly agreed prevails. And those were the initial agreement. Express terms, inconsistent terms, implied terms. So we have dealt with express implied, and then we say inconsistent from, other terms of the contract. And that is why, and this is perhaps as a result of the entire agreement term, which also, so you see, I've spoken about express term, implied terms, an entire agreement term, and then we have inconsistent term. And so I explained earlier before I came to this case about this entire agreement term. You see, because normally in negotiation leading up to, the formation of a contract, it is easy, all right, to make, all kinds of exaggerations, or what we call exaggerated claims as to, if like, the performance and specification of whatever software or computers and the carrying out of various obligations and under the contract. I mean, these are realities that sometimes happen. People really will tell you all kinds of things, right? But normally such representations, which, may be in writing or even oral or even both, can prove troublesome later, especially if one party's understanding of such representation, differs from the others, or if they conflict, okay, with a formal contractual document. And so in some cases, it may be real difficult to know whether, a letter of intent or a letter, setting out the claimant's requirement, or even the software developer's recommendation as part of the contract between. And I'll give you examples of such. I'll give you some other cases that will actually, kind of paint that picture that there seems to have been agreement, but was there a contract, really? Because definitely IT contracts sometimes, because of the negotiation and how it can prolong and all that, there is the temptation to begin working on a contract before even the contract comes into force, or it's all, and so at some point somebody will say, oh, I'm no longer in the contract, and then somebody sues and say, so is there a contract in the first place? Was there a contract? Okay, so these are some of the, so normally there's the entire agreement clause is to actually stamp that up to this point, we have all agreed that this represents the entire agreement, and therefore, there's not going to be any changes. And if there's going to be any changes, then there must be formal, request to make changes, and all of us who are party to the contract would have to sit and make that thoroughly, and let's all agree again that this forms the entire agreement, and therefore, so that if anyone wants to import anything or term into the contract, it will not be consistent with what we have, the entire agreement clause. That's basically what is being explained here. And so I go to establish, let me admit this, guys, and then let me see what next have on my plate. Let's see if I can, I wish I would finish with this side. Okay, so nature of contract, all right? Nature of the contract. Let's see if we can do some 10, 15 minutes and then wrap up, because I can see you guys are tired already. You see, the nature of the contract normally refers to the substance or subject. Sorry. When you talk too much, that's what happens. So I'm saying that the nature of the contract refers to the substance or subject matter of the contract.
Sir, drink water small.
Seriously, I don't even have water here.
Let me let Pat buy some for you. She's bringing one for you.
Okay. All right, that would be great. Yes. Where? Okay, so the nature as a set of contract refers to the substance or subject matter of the contract. And so the substance of the definition of a contract is that by mutual agreement or assent, all right, the parties create enforceable duties or obligations that are legally binding. That is the substance of the definition of a contract. That there is a mutual agreement that we are creating, obligations and duties that will be bound by it, by law. That is the substance of the contract, and that substance becomes the nature of the contract. Okay, so it is it is not always easy to separate, for example, hardware and software. And so although there is some common ground and some similarities in other provisions, contracts for hardware and software are usually governed by different legal rules. So it is most of the time difficult to determine the nature of it, IT contracts. Why? Because, it is not always easy to separate those. The hardware equipment often incorporates software. Hardware and software are governed by different legal rules. And so on and so forth. Please give me a second. Let me take this call. Just a second. All right.
Oh, people tired.
Okay, thank you. So basically, you see, the hardware and software are governed by different rules. And so you would have a difficulty trying to, ascertain the nature or the substance of the contract. And it is very important that we kind of actually going into contract, you need to establish that kind of nature so that you are clear in your mind. And sometimes it is not clear because of the way, hardware equipment and software equipment are, integrated. For example, you buy a laptop. Have you bought, the laptop doesn't come and will not function, only on the basis of, yes, give me a second, guys. Yes. Thank you. Thank you, guys. Thank you very much for giving me water. And let me drink some more. Right. Thank you. All right. So, as I'm trying to explain, computer hardware, if it is sold, would be subject to the Sale of Goods Act. Sale of goods. But that computer is not just hardware. And sale of good contract can happen to any, like you buy set of furniture, sale of good. You go and buy fridge. You go and buy microwave. You go and buy. All those are subject to sale of goods because they are particular hardware or physical something in nature that you buy. So, if computer hardware is sold, we are talking about the Sale of Goods Act and perhaps, related consumer protection legislation, that may actually apply. However, if there is some agreement to write software, it will not be the same Sale of Goods Act that would apply. It will be within the scope of the Supply of Goods and Services Act. Let me admit this. Okay. All right. So the very nature of IT makes it a bit dicey to normally know and establish the nature of the contract. So you can have a Sale of Goods Act and you can have the Supply of Goods and Services Act. This, seeming simple distinction is not always easy to apply in practice because hardware equipment often incorporates software, and the contractual position of ready-made, software is really far from clear. In any case, the classification in terms of the legal nature of the transaction is very important, and the suggested approach is to look at the predominant purpose of the transaction between those two parties. So what am I suggesting here? Did you, the person, acquiring the subject matter, being made computer or whatever, think at the time of acquiring it, you were obtaining a hardware or software that actually establishes the right intention that is behind the contract. It is very important. At the time of going into acquire whatever, whether a hardware or software, did you think that you were obtaining a hardware or software? So it must be so. So, for example, consider someone purchasing a new car. Cars are goods, isn't it? And the transaction comes across clearly that it is subject to the Sale of Goods Act, which, normally the Act, we say, something, contract of sale of goods. Normally we say, because when we talk about contract of sale of goods, we are talking about, a contract by which, the seller transfers or perhaps even agrees to transfer the property in goods all right, to the buyer for a money consideration, which would normally be called a price, fair price. So, there is that seller transferring or agreeing to transfer the property in goods, and that's the Sale of Goods Act. That's why when you buy a fridge, it is yours. You buy, a car, it is yours. So anytime that you buy, there is a transfer, and as I spoke about the last time, of ownership. So the whole purpose of buying a car is a transaction to transfer ownership in the car to the one who is buying it. If I use this same analogy and I suppose that, the car is faulty, and that fault is traced to, let's say, some computer program installed in the electronic ignition system of the car. I won't believe that the purchaser would still expect, and rightly so, to be able to obtain a remedy from the seller under the Sale of Goods Act, even though he, the buyer, has not obtained ownership of the copyright subsistent in that computer program that actually is running in the electronic ignition system, because that is controlled by a software, a lot of embedded software in the car's ignition system. Why? Because the buyer wanted to acquire a car and not that computer program in the electronic ignition system of the car, which is the cause of the breakdown. So though you've bought a car, any electronic, computer program that is operating anything within it does not actually transfer to you necessarily, but you own the car. And what the car is a complete something, and it is the Sale of Goods Act that applies. So, a contract to purchase a computer is seen as such that I am buying a computer. And so it's a Sale of Goods contract, notwithstanding, the inclusion of computer software embodied within the computer. So what is the purpose of buying? I'm buying hardware. That is what is in your mind. So I'm buying a computer. And the seller to you, I'm selling a computer, regardless of the fact that it has some embedded softwares that are running already. What was the intention to actually go into that contract of buying? My intention was to buy a computer. And it comes across as a hardware, it's a kind of a package, something. All right, then let me continue with this, and then, because I don't want to break this nature thing, so that we try to get to a place that, we can all take a rest or something. It's not really not taught yet. Oh, it's past. It's past. All right, fine, no worries. So the nature of software contract would actually be different. See, contracts for the acquisition of software alone cannot be a Sale of Good contract. Because the title to the copyright and other intellectual property is not normally transferred. And in any case, computer programs or databases are not goods. They're not goods. And so I bring the quotation or the definition that the Sale of Goods Act defines goods as including all personal chattels, when I talk chattels and other things, other than things in action and money. So you need to actually get that. So the only condition that is, as far as paper manuals or some magnetic whatever or packaging are concerned. We might have, if like what we refer to as collateral sale of goods contract when it comes to some sort of service. So a software specifically written for a client is a service contract. So the predominant nature of the contract or software contract is the fact that the predominant nature, so I'm talking nature here, is the fact that the contract is the provision of a service. Because when you are going into that contract that they should write a software for you, inherent in it or that purpose or intention is that you want that software to provide a certain service. And that is the purpose of the nature. So that predominant nature of the software contract is the provision of a service. And that which the function of the software is in the service in question that it will provide. So it is so even if the copyright ownership is transferred, and that is if the agreement is an assignment and not simply a license. And I've spoken about assignment. So a software specifically written for a client is a service contract as opposed to a sale of goods contract. Although, tangible things or items such as, those sometimes magnetic discs may be provided. Those days now we used to buy computers, they'll give you other software disk that when it comes you install and it will make the computer run and all those sorts of things. So regardless of the fact that those things are complete, suggesting that a sale of good contract, those things suggest actually that the sale of good contract in reality of the transaction is that of supply of service contract. That's why they give you the copies of those software if they have not already installed them on the system, just as where software is delivered online or by loading it onto the client's computer. So the fact that software can be transmitted without the need a tangible career reinforces the view that software as service contracts. Please, the one talking, who is that? Caleb, please stop talking. So at best, any tangible item delivered with a software gives rise to a collateral sale of goods contract in respect of those items only. Okay, so it is very practical that we begin to understand the nature of contract from that point. So in terms of nature, we can have the supply of goods and services contract, and then we can have the sale of goods act. We can have the sale of goods, contract governed by the Sale of Goods Act, and the purchases of, let me admit this guys for long. Okay. And therefore, we need to be able to distinguish between these two. All right. Now let's look at this, for example. When we talk about software acquisition, let me quickly hit some points here. See, the most common method of acquiring computer software is by way of, a license, which is normally granted by the copyright owner to the person or company acquiring a copy of their software, given, some permission to use the software in return for the license fee, which normally we call the license fee the price. Service separately in class. You see, the license may be for a fixed, perhaps even renewable period of time, or there may be no mention of duration at all, in which case it can be assumed that the license will last as long as the software is subject to copyright protection, right? Okay. The copyright owner would prefer to grant a license because he would want to actually retain the copyright in that software and be free to grant licenses to others, and so on and so forth. And we did talk about exclusive licensing, and I spoke about the fact that, a license may be exclusive, which means that the copyright owner cannot grant licenses to others or the same license to others in respect of that, software. So more usually, you will see the licenses will be non-exclusive, so that the copyright owner will be free to grant licenses to anyone else he wishes or would deem to do that. It's part of their business strategy. So an exclusive license, might be appropriate in connection with some bespoke software written for client in accordance with the client's requirement. And sometimes the ownership of copyright will be transferred instantly. Okay. And in that form of transaction, we'll call an assignment of copyright. So I'm trying to, still, go over what I've already explained between exclusive license and an assignment license that is based on assignment. Okay. Okay. All right. So haven't actually established that similarly when it comes to hardware. So when it comes to hardware, you see the method of acquiring that is by, outright purchase, isn't it? Or sometimes, not all the time that we do outright purchase, sometimes we actually hire, okay? We can hire, someone's hardware. For example, now that, organizations actually have their cloud services and those kind of things, most of these, they have the equipment or whatever thing that it makes them able to actually provide such services on the basis of just renting, just like when you go and rent somebody's custom bonded warehouse or put your stuff in there, that's so. So if normally purchased, the Sale of Goods Act would apply, and terms as to, for example, the quality, complying with description, satisfaction, and all those kind of things, would apply, as, we talk about, because if you buy any normal thing, so the fitness for purpose, appearance, and then freedom from minor defects and all those things, actually are quality aspects that come to play when you actually buying any, hardware stuff. And so when we are buying hardware, in terms of IT hardware, we know that we are actually doing outright purchase or by hire, and that is why. But you see, when it comes to computer, it doesn't just lend itself by easy. So even though you buy a computer with software running on it, you purchased it, but because of the nature of IT, as I keep saying, the software running on it is not an outright purchase or even higher. For hire may even be more sensible, because at the end of the day, it will have a tenure for hiring and may require renewal and all those kind of things, and that's the license. And that's why your license on your PC or laptop may actually expire, and if you don't go buy a new one, you may even be able to use the old one like that, but there are certain features you may not actually get or be able to access, and nobody will come after you anyway until if you want those improved features, then you must actually purchase or renew your license to cater for the new update on that. So the Sale and Supply Goods of Act, or the Sale and Supply Goods Act, sorry, it requires that goods must be of the right quality, right? Okay. On the other, if the supply goes beyond the mere supply of the equipment, and for example, carries out some work as assembling and installing the equipment, all right, then it is no more the Sale of Goods Act. And I'm talking in terms of even hardware. Then it goes to the Supplier of Goods and Services Act. And that is the act that will apply. And if the contract is for the hire of the equipment, right, then the Supplier of Goods and Services Act will also apply. Whether or not installation or other services are also provided by the supplier anyway. So it is very instructive to know the nature of the contract. An agreement which is described as a lease or a rental is essentially a contract of hire. And a hire agreement is one under which, you know, the possession of the goods passes to the other party, but the property in the goods, in this case, the ownership, remains with the supplier. And that's why when it comes to, you know, going into the hiring or using, you know, for example, the cloud services of some other organization and all those kind of things, it amounts to hiring their if like their physical infrastructure or, you know, virtual infrastructure. The ownership does not become the actual possession of the goods will pass to you, the hiring, you know, party, but the ownership remains with the supplier. And it must be understood, you know, in that sense. I want to touch on breach of contract. I don't know. Okay, you know what? Let me actually rather end it here because there are some key stuff that I want to talk about here, and I want it to be at the point where you actually are not tired. Because I think there are some stuff, okay, yeah, these things, and I think I have some. This one, do I have? Okay. Okay. So there are some things, okay, let me see. Okay, let me see. Okay, so this is the, okay, I will need you to be in your fresh state to talk about this. Not too many left, too much left, actually, in terms of slides, but I think I need you to be in it because I'm going to talk about certain aspect that, you know, is very critical. See, we have been talking about breach of copyrights and those intellectual property rights, right? And I'm starting the breach of contract relative to this because, in fact, after this, the next topic that I'll treat is a bit elaborate, and that is the contract for writing softwares, which means that we will start that, we'll complete this